Know how every damn thing's addictive these days? Yeah, the Massachusetts State Supreme Court just decided unanimously that Instagram is addictive and Meta can be sued by the Commonwealth, even though they haven't been shown to have violated any state law and no one cares about the First Amendment or Section 230. They ruled, the Commonwealth alleges that Meta Platforms Inc. and Instagram LLC, collectively Meta, engaged in unfair business practices by designing the Instagram platform to induce compulsive use by children, engaged in deceptive business practices by deliberately misleading the public about the safety of the platform, and created a public nuisance by engaging in these unfair and deceptive practices. They got around all of that by making it about conduct, not speech. The claims do not seek to impose liability on Meta for information provided by third parties. Instead, the claims allege harm stemming from Meta's own conduct by designing a social media platform that capitalizes on the developmental vulnerabilities of children. At least at this preliminary stage of the litigation, Meta has not shown it is entitled to the protection provided by Section 230C1. The challenged design features, e.g. infinite scroll, autoplay, IVR, and ephemeral content, concern how, whether, and for how long information is published, but the published information itself is not the source of the harm alleged. Instead, the claim alleges that the features themselves induce compulsive use independent of the content provided by third-party users. And to top it all off, they even sounded off a huge signal that age verification should be a strict standard for websites, browsers, and OSes by basically declaring that if the age verification isn't up to scratch, then the service can be held liable. Quote, here, the Commonwealth asserts that the defective age verification features give rise to heightened harm to underage users who are particularly vulnerable to the design features challenged in Count 1. The Commonwealth does not allege harm stemming from the content of any information published. So it's not even about nudie pictures or anything. We have to protect the children from infinite scrolling! But minors have First Amendment rights too. That's another thing that's being neglected here. This isn't just about Meta's First Amendment rights, but the rights of all of their users as well. And the very thing that's gotten them in trouble, the fact that people spend a lot of time on the app, is what lets us know that the people do desire to receive the protected speech of the people posting it. Eugene Volokh and Jane Bambauer had sent an amicus brief to the court, which basically went ignored. Quote, their choices about how to craft and format those products are presumptively protected by the First Amendment. That protection extends to the very features the Commonwealth demands Meta remove. Push notifications, for instance, allow social media platforms to speak to users about new content. Endless scrolling, autoplay, and ephemeral features let social media platforms decide how users see speech on the platforms, just as a newspaper chooses how to format the front page, or a film director chooses whether to break up a movie into multiple episodes. Whether those features constitute Meta's own direct speech, or are structural decisions about how Meta presents third-party speech, they stem from constitutionally protected decisions about where, when, and how speech is communicated, and as to the like button, what speech is communicated. And that includes minors. Quote, like adults, minors are entitled to a significant measure of First Amendment protection, and only in relatively narrow and well-defined circumstances may government bar public dissemination of protected materials to them. Protected speech cannot be suppressed solely to protect the young from ideas or images that a legislative body thinks unsuitable for them. Brown struck down a restriction on violent video games, regardless of the ideas the games conveyed. The same principle applies to other display and content features such as autoplay, likes, and endless scrolling. And the lawsuit improperly asks judges and juries to second-guess Meta's choices about how its users communicate with each other. If you say, you can say whatever you want, but only in the way we want you to, you've violated their First Amendment rights just as much as any other restriction. Quote, the Commonwealth characterizes Meta's design features as independent of content and therefore not within Moody's protection. But this is a false distinction. By expressing disapproval through its content moderation policies, Meta may approve of and encourage speech through its design features. For example, the like function is a design feature that helps shape the content of Meta's products by adding extra information to each post, the number of likes, by encouraging users to post popular content that draws more likes, and by encouraging users to read more popular content that has drawn more likes. There's nothing about this that isn't expressive. Design is expression. Method of communication is expression. Format is expression. And anyone who read this amicus brief can see that easily. Quote, "The Commonwealth claims the power to regulate a social media's platform design decisions concerning where, when, and how speech is communicated, and, in the case of likes, what speech is communicated. But the First Amendment provides protections against speech-based negligence claims, as this court and other courts have recognized. And this First Amendment also protects speech producers expressing their views about whether their speech is valuable and harmful. The Commonwealth's attempt to regulate Meta's speech thus fails heightened First Amendment scrutiny." Design isn't just a technical thing. It's a vital part of how communication happens and how effective it is. You don't get to sue someone just for doing it well.